Ladies and gentlemen, welcome to Columbus State Television. I'm Michael Baltimore, the director here, and today we have a very special guest with us, Jeffrey Timmons. Jeffrey is an attorney from Atlanta. He's come down to visit with us and consult with us on some of the things we're doing here at Columbus State Television. You know that we are on various platforms. Of course, we're on 98 and 99 channels on Mediacom. We're on your Roku box. We're streaming to the web at csu.tv. We're on podcasting on iTunes. So there's a lot of things going on. And as always, we need good advice about this. So it's been very nice, and we're honored to have Jeffrey Timmons with us today. And Jeffrey, thank you for being here.
Thank you, Michael. Thanks for inviting me.
All right, it's great. Could you, I'd like to start and just introduce, let you introduce yourself to our audience. Tell us a little bit about your background. We know that you've worked with the FCC, and you have this background for many years now in broadcast and television legal matters. So tell us a little bit about your background.
Sure. Actually, I graduated from law school at Catholic University of America in Washington, D.C. in '93, and I've been in the private practice of law since then as a communications attorney, representing primarily radio and TV stations before the FCC. I didn't actually work for the FCC other than as an intern when I was in law school.
All right, get that.
But you know, during representing radio and TV stations, they face a lot of the same copyright issues that you and I have been talking about today, that would similarly apply to the content that you create for CSU TV and stream over the internet and broadcast over the Mediacom channels. So be happy to talk with you about those today.
Well, that's really great, and I appreciate you taking the time out of your busy schedule and being with us today. And as some of you who watch this may know that Jeffrey's also been in a couple of meetings, and we have some open meetings this afternoon here at Columbus State University. So yeah, we are concerned about copyright and licensing fees, because now this project is growing quite a bit. We're on a number of platforms I mentioned a moment ago. We want to make sure that we're doing the right thing. We want to make sure that we're protecting the rights of the copyright holders, and we're doing the right thing. But I've just got a feeling there's a lot of misinformation out there right now, and people are either afraid or they're going too far in the other direction in terms of creating content for television and our streaming and on the web as well. So, I mean, can you talk about some of the main issues that people need to know as they come in and start creating content, like we're doing today, as a matter of fact?
And it's important for Columbus State because you're on both sides of it. Not only are you have instances where you may be using copyrighted material, or got to make sure that if you use copyrighted material that you have permission to do so, or right to use it under fair use or some other policy, but you're also a content creator that's going to have copyright rights that you'll want to protect as well going forward. So really on the both sides. So I guess the starting point for copyright is understanding what it is and what its purpose is. And copyright applies to original works to protect the creator of that original work's interest in their creation, so that they can profit from it, control how it's used, and that sort of thing. If there was no way that a writer or a songwriter or a composer of a play could profit from the work, there would be no incentive for someone to, or much less incentive for someone to create those type of works, and then society as a whole, the public, would not receive those benefits. So it's important historically to protect those rights, to give creative people that kind of protection and that kind of incentive. And it's important to understand that one of the primary distinctions is that you can copyright the original work, the expression of the idea, but you can't copyright the idea itself. So there's sort of a dichotomy there between the expression and the underlying idea. But what copyright gives you, if you're the creator of an original work, you have the right to control when and how it's performed publicly. You have the right to control when it's reproduced and how and by whom, how it's distributed to other parties, how derivative works, if derivative works are made and how they are made, and displays of your creative work, among some other rights. But those are the general rights that we're talking about here with copyright. And sometimes multiple rights, copyright rights, are involved in a particular discussion or question. For example, you know, here at the university, I understand that the drama department produces plays, and you may want to videotape those and play them back over CSU TV is one of the things that's being contemplated. Well, the playwright, the author of that play, you know, has a copyright in his play and his work, and the you know, before the university can produce the play, they have to get a license or permission from that playwright to do that live public performance. Well, that gives the drama department, or whatever the right name for the department, the group of students to produce the play and perform it live, but it doesn't extend necessarily to allow you to videotape it. That'd be a separate or additional copyright that the university would make sure, would want to make sure that it has before it would videotape and air it over other medium, whether it's streaming on the internet or over the Mediacom cable TV channels that currently carry the CSU TV program.
So various levels of the...
There can be multiple levels, and so the owner of the right, you know, controls what's done with it. You know, they can control whether they give someone else permission to use that work or not, and you know, they can give you a right to perform it but not reproduce it or copy it. They can limit the duration of time. They can say, okay, you have a right to do this for, you know, 10 performances of the play over the next month, or you can have a right to do, you know, air this videotape that you produce for the next 3 years. You know, they can limit how you distribute it. They can say, okay, you have a right where you can stream it over the internet, but you can't put it out over the cable television channels. You know, so or they might allow you to do both of those, but say you can't create a videotape and reproduce copies of that videotape, or I guess DVDs now, or Blu-ray DVDs now, rather than videotapes. Show how old I am. And distribute them for a profit. You know, so they can, the owner of the copyright can control how their work is used and who profits from it. So.
Well, that certainly makes sense to me, that we protect those rights of the copyright owner, and that we pay the fee if there's a fee involved, or if it's public domain. I heard you talk earlier in the meeting about public domain.
And that's exactly true. There's multiple ways that you can have permission to use a work that's subject to copyright. One is to have permission directly from the source. You know, go directly to the person that owns the copyright, request and get permission. They may charge you a fee. It's often called licensing. You know, that's a license. Second way is if in the United States and in most countries now, there's a time limit on how long the copyright applies. So at some point, it'll pass into what's called the public domain, where the copyright no longer applies. Anyone can air it or modify it or do whatever they want with the work at that point. And that length of time, unfortunately, has varied over the years. It's set by federal statute by Congress, and it's changed a number of times over the last century, so it's sometimes difficult to ascertain whether something's in public domain or not. And then sort of a third way is if some type of fair use exception applies, where you know, where the creator of the work does have a valid copyright, but a particular use of it's considered fair and non-infringing, whether they give permission or not.
And that particularly applies to educational institutions as much as some of the others, I'd say.
Probably more often. You know, there's sort of 4 factors that are looked at and determine whether something's a fair use or not. And one of them is the, you know, the purpose for which the work is used, and another is the effect of the fair use on the copyright holder's potential commercial market or value for their work. You know, are 2 of the factors. Some other factors are the how much of the work is used, whether it's, you know, just a small clip or fraction of what's being used, as opposed to using the whole work. Another is the nature of the work. You know, is it something that's intended to be educational, or is it something intended to be commercial? So the important thing to understand about fair use is it's not a set formula. You know, it's not a mechanical formula that you can apply and say, in all circumstances, yes, this proposed use is fair use. It's very fact specific and based on the circumstances of the case, and you have to look at all those factors and weigh it.
Right, so there may be a weighing of those
Correct.
different factors.
And of course, the copyright holder may weigh them differently from you, and you'll end up in a dispute, which sort of leads to the next topic, which might be, you know, what's an infringement, what's not, what happens if you infringe. And I guess the way I would describe it is you want to make sure there's one defense called the innocent infringement, where if you've been diligent in trying to determine whether something's in the public domain, or diligent in trying to have it licensed. For example, if you have music that you're going to air during your video, there's licensing agencies, ASCAP, BMI, CSAC are the three most well-known that cover probably 95% or more of the music that's out there that's not public domain.
Those are clearing houses.
Those are music performance license clearinghouses. Yeah. So they'll license you to use music, for example, on a radio or TV broadcast, or in streaming over the internet. If you have any music, there's a license for streaming over the internet. You know, but getting back to making sure you don't infringe and how not to do that.
That's pretty important.
You can show your due diligence by checking whether it's in the public domain. If you determine that it's subject to, you know, that the copyright holder participates in ASCAP, CSAC, or BMI, you can cover yourself by purchasing the license, which are fairly nominal depending on your use. Third way is by attempting to clear it with the source. And you've taken all those steps and been diligent in trying to ensure that you don't infringe, then you've put yourself in a good position to argue. If you do get the undesirable letter from some Atlanta or DC attorney saying you've infringed on my client's copyright, you can reply and say, well, we didn't think we did because we searched whether it was in the public domain and found it in the public domain, or we you know, it's music and we believed we saw that it was licensed under BMI or ASCAP and we have a license, or maybe your argument is a fair use and say, okay, we considered this a fair use because it's a very short, you know, it's a 10-second clip out of an hour-long video. We don't air the audio, and we're using it for an educational purpose. We're using it to critique a movie, or we're using it for a bona fide newscast, and we're not benefiting from it commercially. Therefore, we believe it's fair use. And if you make those kind of showings in response to the, you know, the notice of infringement letter, they're probably going to realize, hey, they got a pretty good defense. It's not worth our while to pursue an enforcement action because we're unlikely. We'll spend thousands of dollars in legal fees, and we're unlikely. It's at best 50-50 whether we collect any damages. So the parties will agree that we won't go any further, but you won't use that music anymore, or however they resolve it. So the goal may be not so much as to never infringe, but as to make sure that that you've been diligent in trying not to infringe, so that if something does arise, you can work it out in a mutually agreeable way without ending up in court spending a lot of money on fancy attorneys.
Well, that's very interesting. I'm glad you're talking about that, because it's not just here, but students in general, but those, we had this conversation earlier about everybody's got a camera on their phone, they're taking video, they're posting it on YouTube, they're taking things down off YouTube. There's just a lot of misinformation, and I think just not really understanding the concept of copyright and how we need to get licensed for that, or have ownership, or have permission from the source, as you've talked about in the other ways. What would you tell students who are watching this today? Okay, guys, listen up. Here's some things. These are some must-dos. When you are going to put some content on Columbus State Television, you need to go ahead and consider these things prior to coming in here. What would you tell them?
Probably the first thing I would tell them is that the defense of everybody else is doing it doesn't seem to hold up in court.
That doesn't work so well.
That's not a defense that I would intend to rely upon.
All right. Good idea.
You know, as I said, copyright exists just by the creation of the original work. I mean, you're advised to put a notice on it. If you do create an original work, you want to put a notice that says, you know, the copyright symbol and the year and your name as the copyright holder. And you may even want to register it with the Copyright Office in DC, which gives you some statutory protections. One, it lets you collect a statutory damages and instead of having to prove actual damages.
Okay.
But
yeah, because
if you ignore the copyright, you do it at your own risk. Now, you may not get caught. I mean, when you say all your friends are doing it, or everyone does it, that doesn't mean that's not infringing. It just means that they haven't been caught and subject to an enforcement action.
Right.
But you don't want to be the one that is caught.
No, you could be the one. That's right.
We were talking at lunch. I guess one of the seminal cases, it was a college student back in the mid-'90s had downloaded music from Napster. This is one of the early cases, and you know, part of their argument was, well, everybody downloads from there, and I think the suit was actually bought by the RIA, the Radio Industry Recording Association, and the college student lost. You know, I think his damage was, you know, the judgment against him was on the order of $160,000 from memory.
Not good.
So, you know, there might have been a couple million people that were downloading stuff from Napster, but he was the one that got caught, got hauled into court, and ended up with a judgment against him, and was made an example of. But you know, it could have been any of the other million people that were downloading that could have ended up in the same position.
Could have been.
You don't want to be the person that gets caught and subject to enforcement.
No, not so. Take those precautions. So, you know, sometimes I've seen people bring in. They'll shoot a video, but then they'll put a soundtrack underneath of a popular song.
Right.
Not
Guess
a good
what?
idea.
That song, the artist holds the copyright to that song, and if you use it without permission or subject to fair use, and it's not in the public domain, you violated their copyright.
Right.
And you could end up with a enforcement letter or notice of infringement letter from some attorney, or more likely, if they're doing that to upload it to YouTube, or some other online service like that.
Right.
Well, a lot of people don't read when you sign up for YouTube. You have to go through the licensing and just click, and most people just scroll down and don't read the 10 or 15 or 20 pages of legalese. But in the middle of that somewhere, it says that that you won't use copyright content without a license or permission. And I haven't read it lately myself, but I'm sure it has something to the effect that is, and if you do, and you cause damages to YouTube, you're going to have to indemnify and pay them for, reimburse them for their costs of any enforcement action they end up liable for. And they have mechanisms where they look for copyright progress.
Run the algorithms.
People that view it can send notices to YouTube and flag it, saying this has copyrighted music in it. And YouTube, and other. And I keep saying YouTube; it's just the one that comes to mind.
Sure.
But any service like that has policies where they not only passively respond when things are flagged, but also where they proactively look for infringing uses of copyrighted material so that they can pull it back off the website. And if you do it often enough, I'm sure they probably contact you, or ban you from using their service, and or contact you, or worse, contact the copyright holder to let them know that you're infringing on their copyright
and then take
on a regular
action.
basis.
That's right, and to take action is there.
The bottom line is you don't want to end up on the wrong end of an enforcement action.
No, you certainly don't. So. We want to encourage people to continue to create content here for CSU TV, and we like to think that we can create those ideas. They can create those ideas without infringing on others' copyright, that they can own their own copyright. We've certainly done that with a lot of our shows and our content for CSU TV. Well, this has been very helpful, Jeff. Thank you so much for being with us today here in our studios at Columbus State Television. This is Jeffrey Timmons, an attorney, and he's been gracious enough to stop by the studios, talk a little bit about copyright. We hope it's been helpful to you, and continue to tune in to CSU TV. We'll see you next time.